So today is all about the California updates and federal updates to the laws. The good thing is that due to Trump being in this administration, there's not too many federal updates. We mainly just have California state law updates. So our agenda is pretty simple today. We're just going to go over any of the new laws that are going to be taken into effect as of January 1st. And then we're also going to go over common mistakes that we're still seeing employers make, even with pre-existing laws that are in place. Starting with our minimum wage increase. Starting January 1st, 2026, the minimum wage will increase for the state to $16.90. That is per hour for all employers statewide. This change really is going to be impacting all employers statewide. Sorry, give me one moment. It's going to be really affecting all employers statewide. And so it's important that you go ahead and check to make sure that your business currently is in compliance. Now, that's just the state threshold. You want to also look at your local threshold as well, which we're going to get to in the next slide. But as well, it's important to note that for your employees that are salaried, that is increasing as well to $70,304. And so if you are not going to be meeting this threshold, then it is important that you either reclassify your salaried employees to making them non-exempt and begin paying them overtime. Otherwise, you're just going to need to increase their salaries. Then if you take a look at this screen, it's going to show you basically based on each city what the increase is going to be. Some of the dates are different and they already started, or some are starting later on. Some of them are classified based on a certain number of rooms that your hotel has. And so feel free to take a screenshot of this slide, or if you'd like, you're more than welcome to reach out to me after and I can provide a copy of this whole entire presentation. And then as well, if anybody has any questions, our goal is to get through all the slides today, and then I'll be addressing any questions kind of at the end. So feel free to put it into the chat box, and then I can go ahead and respond at the end of this presentation. And then as always, my email is always open. You guys can send me questions as we go. All right, so starting with SB 590, this is the Paid Family Leave Act. What's important here is really about the employer perspective, right? Now employers must allow eligible employees to take the protective leave, and they can't interfere or retaliate against their employee for requesting it. Now this has already been in effect, but what's different here is that the definition now for a designated person has been expanded, where before it was thought as just being a blood relative, it's really expanded into anybody that the employee believes, that they consider to be family, essentially. And so really at the time that they submit this leave to you, then they just need to identify the designated person, and then essentially they're being honest about it, right, under penalty of perjury, that they actually do consider this person to be a family member. So that's the only extension of this. It's really just broadening the idea of what a designated person is. Then we go into SB 294. Basically, this is all about notifying your employee, or it's all about when an employee is detained by ICE or if they're arrested for some reason. The whole idea here is that we want to make sure that each of your employees have some type of emergency contact on file, so that in the event that they were to be arrested or detained, you can immediately reach out to whoever that contact is going to be. Now, you have to, starting January 1st, provide this notice to all of your employees that are existing, and then provide it to any new employees that are joining. What's different here is that the Labor Commissioner will actually be providing this notice. As of now, they have not provided this notice. And so we are still expecting it to be published. And again, they said that they're going to be publishing it January 1st. It may get delayed, but reach out to us if you want a copy, or take a look at the website as of January 1st, and you should see that form and notice there for you to be able to download. And then what's really important is this notice has to be given on an annual basis. So it's important now that whoever your management team is, whoever that's going to be, is that they go ahead and put that in their calendar, that every year this needs to be given to any existing employees. And then also, by March 30th, 2026, Any of your existing employees, you have to provide them with the paper so that they can actually designate who that emergency contact is going to be. Our recommendation would be having on that same notice a checkbox and a form that basically says, yes, I would like to designate somebody and this is their contact information, but also, no, I would not like to designate anybody and that they're voluntarily choosing that. And so you're covered either way in the event that someone claims that you never provided them with that notice. So look out for that starting January 1st. And then again, mark in your calendars March 30th, 2026 to comply by. Then we get into training records. So SB 513 is basically broadening the scope of what qualifies as personal records. So now, I'm sure many of you guys have received those demand letters before in the mail or via email where somebody is requesting their employee records, whether that be another law firm or that be the employee themselves. So now what's included in those personal records is actual training records. And that means you have to, or your management now has to actually start maintaining these records themselves. Now, it's not just notating down that the person's been trained. There's specific things that you now need to notate in these training records. And we've included this list here, including the employee's name, who provided the actual training, how long the training was for, what skills and core competencies were included in that training, and then was there any type of certification or qualification now that they're designated as, and then attaching a copy of whatever that certification is to the actual training record. Really, the simplest thing for you to do is to create an Excel sheet for each of your employees. And that way, each time there's an updated training, you can put this in there. Now, a lot of questions that we've gotten is what type of trainings does this include? And it's anything and everything you're training your employee on. So if you've got a new front desk clerk and you're training them on your PMS system, that's a training that needs to be logged. If you've got a new housekeeper and you're showing them how you make the beds at your property, that needs to be logged. It's every single training. Now, we all know that there's certain OSHA training requirements, there's certain other California state requirements like human trafficking, things like that. And LA, we have that new housekeeping ordinance training. All of these trainings need to be now logged. And so this is another kind of gotcha way that employment attorneys that are going to try to come after you are going to see to try to say that you never gave certain trainings. So make sure you've informed all of your staff now that these are trainings that need to be recorded and that you actually make sure you're really giving your employees these trainings. Bias mitigation training. So it used to be where if a employee or if like a supervisor were to get bias mitigation training, then later on an employee plaintiff that goes to sue that employer can say, see, it's proof that this guy was biased. That's why they had to give him bias training. So now basically plaintiff employees are no longer allowed to use bias mitigation training against their employers. And so this is not a required training at this time, but it's something that's optional. If you have an incident that occurs with maybe one of your supervisors or your managers, you may want to institute some bias mitigation training. It's just something for you to know that they can't use it against you later on. Okay. And then we have Division of Labor Standards Enforcement under SB 261. So basically, if an employee files something with the labor commissioner against you and they award whatever amount, let's just say they award $1,000, you basically have 180 days to pay that award amount. Now, there really wasn't any penalty if you failed to pay it. So a lot of employers just chose not to pay it and just let it sit there. And so now they're instituting penalties if you fail to pay it. And so the bottom line is you just need to pay it if you get one of these damage awards. Failure to pay it, honestly, it's going to be almost triple the times the amount of whatever that award was. Whoever the attorney that comes after you to try and recoup those fees, you're going to have to pay their attorney fees as well. And so it's better to just pay the fees if you get a judgment against you and then move forward from there. Then we get to the crime victims leave expansion. So we all know that this was already something that was in effect even last year. Notably, this is really only applies to employers that have more than 25 employees. But what this expands on is when it comes to the definition of really what a victim is. Now, what we all considered it as was really domestic violence, but now this definition expands it into being, sexual assault, if it's child abuse, any type of DUI charges, manslaughter charges, things like that. And so, if your employee comes to you and they say that they're a victim of one of these charges or that a family member of theirs is a victim of one of these, then you essentially need to provide them leave for that. Now, this isn't just leave for the incident itself, it's also for any of the judicial proceedings that are related to that crime. So that's including post arrest, pleas, sentencing, etc. If you're ever confused about, what's allowed and what's not allowed, you can always reach out to us and we'll be happy to assist you with navigating that. And then same thing for jury duty now. Basically, the requirement is that if an employee gets subpoenaed to do jury duty or they're supposed to appear for court because of a subpoena, then they have to provide you with at least some type of reasonable advance notice. Now, if they fail to provide you with that advance notice, you don't necessarily have to give them that time off, or you could essentially take action against them like a warning notice or something like that. The only exception is if it wasn't feasible, right? If last minute they just found out and then they attend and then they provide you later on some type of evidence that shows the reason why they were absent and how reasonable it was for them not to give you notice, then you really can't take any action in against them. But the bottom line just comes down to once they know that they need to appear in a court proceeding and they give you notice, you can't retaliate or do something against them, right? Find somebody to cover their shift and then move on from there. Next, we get into posting pay on job ads and equal pay. And so we already knew that we had to post the pay scales, right? A lot of us were posting for like front desk clerks, maybe a range from minimum wage until $40 or $50, just so that we were covered by this. But basically, what this law is doing is amending this, and it's redefining really what pay scales means. And it's saying that this is really an estimate of the expected wage range that an employer will reasonably expect to pay for the position upon hire, and that you're making it in good faith. So the idea is that they're tightening the range now, right? We can't say we're going to pay the front desk clerk between $16 and $40. A more reasonable understanding would be maybe between $16 to $25, right? Now, there's no definition of what reasonable would be, but I think that we can all assume and guess what the max you would pay a desk clerk is, and that should be the highest that you're putting on the range, right? Or what the max you're going to be paying a housekeeper, and that should be the highest on the range. And then always the minimum should be whatever the minimum wage is. It's important as well for equal pay. This now includes, before it was females and males, now it includes non-binary individuals, basically meaning you got to pay everybody equally. It doesn't matter what their gender is. And then additionally, it used to be a 2-year statute of limitations from the date that the cause of action accrued, but now it's expanded into 3-year statute of limitations, basically giving an employee more time to sue you if they feel that you didn't equally pay them based off of their gender or if you violated this pay scale rule. And so it's important that you go through and look at your job descriptions, make sure that you adjust this accordingly, and then just keep in mind that in terms of the definition of what wages is, it covers everything from bonuses to stock to allowances, really anything and everything that you're giving to your employee as a benefit to be a part of the company. Just make sure it's equal across the board. And then we get into tips. So per SB 648, when it comes to tips and gratuity, basically you need to make sure that you are providing these tips to your employees without deducting any credit card fees from these. And then you also need to make sure that your managers and your supervisors are not participating in getting any of these tips if you do like a tip pooling system. Now, it used to be where in the labor commissioner any type of like gratuity theft or failure to pay the gratuities weren't a part of a claim that you could make to the labor commissioner, but now it is. And so it's really important that you do abide by these rules, even taking a little bit off of it or having your managers be a part of it. It just doesn't fly, and you will get penalized by the labor commissioner. And once they get the claim, they're like a dog with a bone with it. They're not going to get rid of it until they come to an end. And it's typically going to be a damage award against you. Now, for violations, you can see here, initial violations, you're going to be subject to a $100 civil penalty for each of your employees. And then there's subsequent violations as well. So the bottom line is really just make sure that in terms of tips, if you are collecting them, make sure no credit card fees are getting deducted, and to make sure your managers and supervisors are not participating in those tip pools. Those are really the most common lawsuits that we're seeing right now when it comes to tipping. Other updates. So right now, there's the right of recall. Again, this only applies to hotels with 50 or more rooms. This was an extension, if you guys remember, during COVID. Uh, Basically, it required that any of the employees that were laid off and you posted a new job, you were supposed to send out a notice or a mailing to these laid off employees, letting them know that a job position has opened up if they had qualified for it. And so this is an extension from COVID still. So if you had laid off any employees during COVID, then from now until end of 2026, you still must notify that employee via email and written letter within 5 days of posting any job that that employee may qualify for. And then you must give that employee 5 days to respond before giving that job to another employee. AB 692, in terms of contracts in restraint of trade. This doesn't necessarily apply to everybody. It's basically called stay and pay. It's where, let's say you offer relocation expenses, or maybe you're getting an employee and you're paying for their green card application and things like that for them to remain there. And you're telling that employee, well, you have to remain here for at least 3 years. And if you don't remain here for that amount of time, then you're going to have to reimburse us for those fees. No longer can you say that anymore. And so that is now forbidden under AB 692. Keep in mind, it doesn't apply to things like loan forgiveness or tuition payment programs or any type of like retention bonuses. There's specific items it applies to, and it's mainly like relocation, green card expenses, things like that. And if you were to have anything like those loan forgiveness and tuition payment programs, just make sure that you have separate agreements from your employment contract, and that's what keeps it separate. And then we jump into SB 464. It doesn't actually take into effect until January 1st, 2027. And it's really mainly targeting employers with 100 or more employees. But as of that date, there's going to be 23 categories now that you're going to have to segregate your employees into. And then you have to file this data on an annual basis. We'll touch on it again next year when we do the same session for 2027 updates. But it is on the horizon, so we just wanted to briefly touch on it now. And then the WARN Act, again, this only really applies to employers with 100 or more employees, but this is all about notifying employees of any job search services they're offering in the event of a mass layoff. So if you're going to be terminating 50 or more employees within a 6-month period, then the WARN Act basically says you have to give a warning to these employees. You're not required to offer job search services, but in the event that you do, now you have to include that notation within the same letter, and then you have 30 days to offer those job services within the time of layoff. Poster updates. So every year we should be updating our posters. We've got links here. Again, happy to provide you the presentation or shoot me an email and I can provide the links to you there. But the bottom line is you've got to get your posters printed, get it posted by your time clocks, and then there's a bunch of other notices and things like that you're required to have. Typically, these posters have them. If they don't, they'll include it as well. But a full list of any of the required posters and links to download them all are all located here. And so, like I said, we're happy to provide those. And then we jump into handbook acknowledgments. So it's nothing new. It's something that's been there. It's consistent, but your handbooks need to be updated on an annual basis. Like I said, not too many federal changes. It seems to mainly be California state law when it comes to the changes that we're seeing this year. But still, we've got to keep those handbooks updated, and not only updated, but we want to make sure your employees are signing a new acknowledgement each year, basically affirming that they're agreeing to whatever those new rules and notices are for that year. So reach out to us if you need an updated copy. And at the very least, if one of your payroll companies are offering a handbook already, just make sure at the very least your employees are signing this acknowledgement. And then arbitration agreements. I have seen a flood of class actions and PAGA suits lately, and it's really important. My first question I always ask is, did your employee sign an arbitration agreement? And half the time I'm getting an answer yes, half the time I'm getting an answer no. So if you fall within that no category, please reach out to us, reach out to whoever you need to obtain your arbitration agreement and have all of your employees sign it. It will really protect you in the long run. I promise you. A lot of those firms that are going out there trying to get these huge suits against you, they kind of shy away when they see these arbitration agreements. So the best thing to do is to have your employees sign it. It's the best line of defense when we do see these PAGA and class action claims. And that's really it when it comes down to our updated California and federal laws for 2026. It's exciting. There's not too many, but there are some important ones that we discussed. Like I said, reach out to me if you need the presentation. I'm happy to provide it to you, happy to answer any questions. In regards to that, what I will do is I'll take a quick pause to take a look at the chat. If anybody has any questions in regards to the updates, I can go over those now. Okay, so the first question was, what would happen for successor liability if the business is sold and under new ownership? The new business still has the requirement and responsibility to adhere to it, and technically you would have the responsibility to adhere to it as well, unless you were to have them indemnify you, right? So in the purchase and sale agreement of the business, my best recommendation would be to have them indemnify you for any of these types of employment disputes that might come later on down the line, and that way you're covered. If you don't get that indemnification, then technically you are on the line until the government suspend this. And like I said, they did extend it up until January 1st, 2027. And so you have until then that you need to continue to comply by. And then if the laid off employee law allows a seasonal employee or any other clearance with 1+ year employment. So it's any employee that was laid off during COVID specifically. And so it doesn't matter what the job title was, it's just any employee that was laid off during that time period. And so if you did lay off that employee, let's just say it was a seasonal worker. If you were to post another position that was seasonal, then you would have to reach out to that seasonal employee to let them know that that job is available, and then give them 5 days from the time that you inform them to either say that they accept the position or decline the position. And even if you have another person that applies for the same job that's more qualified, you still have to end up hiring that person that was laid off over the new person that just applied. Okay? If there's any other questions, perfect. Can you expand on the non-exempt salary of $70,304? Can it be argued that the manager's quarters they reside in count towards this wage amount? And does the court acknowledge this, or is it a shot in the dark? So that's a very popular question that we get. Yes, you can argue that a portion of the manager's quarters is going to be used towards that non-exempt salary, but it depends on how that portion is being paid. Are you deducting it directly from that salary, or are they paying that money back to you when it comes to rent? The reason why that question is important is because there is a smaller amount that you can deduct for when you are automatically deducting it from their salary, as opposed to there is no cap at all when they are paying you back for it. And so, truthfully, if we wanted to charge somebody, let's say $2,000 a month for the apartment, the best thing you could do then would be to pay them the full amount of salary and then have them pay you back each month, whatever the rent amount is going to be for that apartment. Keep in mind, when it comes to the amount that you charge, it's market rent, right? Whatever the market demands. However, if you are deducting that amount already automatically from their salary, it's a much smaller number. I'm pretty sure it's around 980 something. You can email me. I can tell you the exact amount based on the locality that you're in, but it's a very small number that you can automatically deduct for. And so a lot of people actually fall out of compliance when it comes to that. Next question. If an employee keeps calling out, at what point can we ask for reasonable documentation to support their call-outs? This question is not related to illness or anything related to sick pay. You can ask for reasonable documentation for anything that they are calling out for. It doesn't really matter what they're calling out for. You can ask for them to provide that documentation, right? That way you can see if it's going to be falling under anything that we have talked about today, whether it's for jury duty, whether it's the crime victim leave, any of those items, and that way you can then act accordingly. And then lastly, regarding the arbitration agreement, do they specifically have to sign that agreement separately, or can it be included in the handbook and the acknowledgement form signed that they received and understand the employment handbook? So thank you, Crystal. That will be the last question until the end of the presentation. Thank you for asking that. It's a really important one. So when it comes to the arbitration agreement, it cannot be a part of your handbook. Now, if you received a handbook from us, we include it in our handbook, but it's the last page. And if you notice, we don't add those numbers as a part of the handbook. Those are individually numbered as their own, or they don't have page numbers at all. You cannot have a valid arbitration agreement embedded inside of your handbook. The same goes for meal waivers. If you have your employees sign those meal waiver forms that say, if I work less than 6 hours, I'm not going to take my meal break, they have to sign that as a separate revocable document. It cannot be a part of your handbook. It is not valid if it's embedded in those 50 pages of your handbook. So what I like to say is any of these big hot topic numbers, you have them separately sign a piece of paper, even if it's a part of your handbook. Because to me, the best level of defense is when I can show, one, they signed the handbook acknowledgement form, and two, here's a separate piece of paper where they also acknowledged it. But remember, for all of these, including the arbitration, you have to make sure it says this is revocable. If you do not tell the employee that it is revocable within the paper, again, it is not valid. So there's a lot of these nuanced things that have to be included in the paper. Just make sure that you are actually complying and make sure that your agreements are valid. Because you may think that you have a valid arbitration agreement, but it may have something missing or may have something in it that then invalidates it. So jumping forward, we now go into our common employer mistakes. These are mistakes that we keep seeing happen year after year. These are already rules and laws that have been established, but we just want to go over them just to make sure everybody's on the same page about them. Again, feel free to throw questions in the chat as they come up. I will go over all of them at the end, and then if you have to go, feel free to shoot me an email and I can provide you a copy of this or I can answer your questions. Starting with expense reimbursements. So as we started with COVID, a lot of people started working from home or a hybrid option was offered. And so this question came about of, well, what do we pay people when they're working from home? What if we give them the option of working in the office, but they choose to work from home? What if we don't have enough office spaces for these employees such that they have to work from home? So all of these are factors as to what then needs to be reimbursed. So If you are providing a fully equipped office, right, for your employee to work, and the costs that are associated with working from home are not necessarily considered necessary because you're giving them that office space, then you don't have to pay them anything for working from home if that was their choice. However, if they are a hybrid worker where they are required, or if you even encourage them to work from home part time, you have to reasonably reimburse them for any percentage of their necessary expenses, right? We're talking cell phone, we're talking internet usage, we're talking the purchase of their computers, the purchase of their desk, anything that you would have supplied to them at work that they are now using at home, you have to reimburse them for a percentage of that. Again, if you don't have the space to provide them all those things in your office, thus they're forced to do it at home, you have to reimburse them. This is the newest thing that right now we're seeing in terms of in litigation, and so it's important that you're reimbursing your employees properly. At will status. A lot of us think that because California is an at will state, we can terminate our employees whenever we want. And you can, unless you've altered their at will status. You can alter your employee's at will status by the things that you say and the things that you write. So if you tell your employee, like during their performance review, keep up the great work. If you continue to keep making us money, you're going to keep having a job here. You just altered the at will status of that employee. And now, if you try to terminate them, you will run into issues. Additionally, when you're writing that performance review, if you put in there, you know, um, if you reach a goal of making $1,000, you've got job security, or your job here is safe, or anything along those lines, anything that would make it a person think that they have this job security, that they can't be terminated at any time, then you just altered the at will status. So less is more is what I like to say. It's important that you tell your managers that are doing the performance reviews, again, keep it less. Just simply tell the employee how their performance is. Don't tell them anything about the longevity of their job, the security of their job, or anything like that. It's really how their performance is at that time, nothing more, nothing less. Um, a lot of people I've been noticing don't do performance reviews of their employees. Truly, this really helps in the long run, especially when you have a dispute later on, right? Or a lot of times I'll see, hey, my employee doesn't show up to work 10 times a month or isn't showing up 3 times a month. Well, then we ask, well, have you done a review or have you done a write up of the employee? And the answer is no. So if we don't have any documentation on our side, later on when it comes to defending you and your choices to terminate them and that it wasn't retaliation or it wasn't, due to X, Y, or Z, we don't have any proof. And so performance reviews are really important. It helps an employee understand what they're doing wrong, what they can be doing right, and it also builds more documentation for you later on so that we can use it in your defense if that employee comes at you later to sue you. Overtime pay. So we all know that both federally and in California, overtime pay is 1.5 times the employee's regular rate of pay. What we've now been doing is calculating the right regular rate of pay. Regular rate is not just, oh, John makes $16 an hour, so now I'm going to pay him $24 an hour when it comes to overtime. John's regular rate of that $24 also includes any compensation that he would have made in addition to that wage, including commissions, non-discretionary bonus, piece rate pay, and there's an entire list of items online on the law that is included in this regular rate of pay. So if you give any non-discretionary bonus or any type of commission structure, right? For example, if Tiffany gets 10 TripAdvisor reviews with her name in it, she gets a $500 bonus. That's considered a part of this regular rate of pay, and there's a formula to use to factor in how to come up with that amount. Now, what's important is this also jumps into what we're moving into next, which is meal and rest breaks. We all know that there are penalties when our employees fail to take their rest breaks or their meals. That same way that you calculate regular rate is how you calculate the amount of penalty as well. So again, just because Mary is making $16 an hour, that doesn't mean that's how much her meal penalty is. You need to include in there all of those commissions, any type of non-discretionary bonuses, and factor those in. How to calculate each of those regular rates, there's very long formulas to do it. I have examples that I can provide you. I have formulas I can provide you. Again, shoot me an email and I'm happy to provide that to you. In terms of best practices when it comes to meal and rest breaks. We all know, and if you haven't, you've been fortunate enough, I promise you, it's coming down the line eventually where an employee will sue you because they allegedly didn't take their meal or they didn't take their rest break. So, what can you do? Document, document, document. In terms of your time clocks, if you're not using an electronic time clock now, I highly recommend that you invest in it. The reason why is there's things that you can set up in there such that you can make the employee put in there, did you take all your breaks? They can hit yes or no. Did you take an uninterrupted break? Yes or no. Did XYZ, XYZ? You can ask all these questions in there and make your employee submit to that. And it can be in the language that they speak. That way, now you have these affirmations on their time cards that they did take their rest breaks, they did take their meal breaks. It was uninterrupted. They didn't work off the clock after they clocked out. These are all things that you can put in there. Now, I have a list of these affirmations. You can reach out to me. I can provide that to you if your time clock already has that function feature. And that way, you can get those uploaded and make it easy for your employees to affirm. Another thing to note is if your employee misses their meal break and their rest break, that means that is two missed penalties in the same day. One penalty doesn't cover both their rest break and their meal break. You have to pay them 2 hours of pay. And then, like I said, make sure you're calculating it properly as to what it is. Wage statements. Make sure that your wage statements are accurate. A lot of companies are using like through ADP, things like that. It's automatically generated, but it's not always correct as to what is included on there. And so it is your responsibility at the end of the day to ensure that those wage statements are accurate, right? We need to make sure that the gross wages are on there, total hours worked, number of piece rate units, and the rate, any deductions that you're taking, the net wages, make sure the pay period dates are on there, the last four digits of your employee's social security, including their name, the name and address for you. This is not your DBA. This is your corporation name, right? If you're an LLC, your LLC name, your entity name, whatever that official name is, that needs to be on that document, not Holiday Inn Express or Motel 6. And then lastly, any of the hourly rates that were in effect during that pay period. Investigations. So a lot of times employees will talk to their supervisors or managers and just say, "Hey, I'm just letting you know, so and so is making me feel a little uncomfortable. But like I don't want you to take any action about it, right? I just wanted to let you know. That's it." Unfortunately, once they tell your manager or supervisor that, you have to investigate and you have a legal obligation to investigate. So it's important that whoever is doing that investigation, they're unbiased, right? So if the complaint is about your front desk clerk, your general manager, your assistant general manager, ownership even, they could investigate it, right? But if the complaint is about management, then you can't have management do the investigation about themselves. So at that point in time, you may want to hire somebody else to conduct the investigation Typically, an attorney will do that, right? So that way all your bases are covered. I recently just did an investigation for someone that was feeling harassed, and it ended up leading to another employee getting terminated. And so it any complaints, you just have to take it seriously. You have to have all of your documentation, right? That same situation, the employee ended up resigning during the process of the investigation. And so at least now, that employer that hired us is covered. So in the event that she does come back to sue for that harassment, we can show proof of the investigation that we took her concern seriously. And then it's important that you're interviewing every witness there, taking down statements, taking down declarations. Again, if your GM or your AGM is the one doing the investigation, make sure that they are actually notating everything down. Make sure they're getting statements from anybody that was involved in the actual incident and having those people sign as well. And then lastly, delayed investigations. Just make sure if an employee tells you that something's going on, that you investigate within that favorite word, reasonable amount of time, right? And what's reasonable is going to be up to a jury or up to a judge, right? But I think we can all understand that if someone were to report something, depending on the severity of it, right? If it's something like sexual harassment, maybe, then you may want to jump on that, right? Within 2 to 3 days at the minimum, or the maximum of somebody complaining. But if it's something else, maybe you could give it a week maximum. So that's something for you to gauge. And then last but not least, reasonable accommodations. So anytime an employee asks for you to make some type of accommodation, right, there's always again that keyword reasonable. You don't have to go over and beyond, but what a court would look at, right? What an attorney would look at was their ask and was their request reasonable? And if it wasn't reasonable, they'll say, would it have produced a lot of undue hardship onto the employer's operations? For example, let's say I work at the front desk, and due to my diabetes, I can't stand for long periods of time. So I'm requesting now that you give me a chair at the front desk so I can sit during my duties. That would be a reasonable accommodation, right? As opposed to, let's say, I get fatigued due to some disability and I need to take a break every 10 minutes. That would not be reasonable and that would affect how you operate your front desk because if somebody's taking a break every 10 minutes, who can manage your front desk? So it's always a reasonable standard test, right? If sometimes there's a gray area of what's reasonable and what's not, and the biggest one it comes down to, right, is when somebody needs to take medical leave. Now, the rule is they can't just take an indefinite medical leave, right? But they can go for a reasonable amount of time. And recently, we just had a court case where they said a reasonable amount of time is anywhere between 7 to 12 months. So it's a pretty big range if you ask me, but if somebody does ask, technically you do have to give them that time to have off and then up to 7 to 12 months. If it's anything above that, then you may deem that as unreasonable, and then at that point you could technically terminate them. So, like I said, there's not too many laws, thankfully. It's a first. We know California normally has a lot. There's some important ones in there. Feel free to shoot me an email if you want a copy of the presentation. Right now is your time to put in your questions in the chat box. I am more than happy to answer them. If you'd like, you can always shoot me an email as well. I can answer them later on for you. But yeah, it's not too bad of a year this year when it comes to new laws. All right, let's take a look at questions. It says, can you highlight on-duty lunch and breaks agreement for front desk with single shift without any supervisor on duty or any housekeeper available to relieve a lunch? So technically the law says that when it comes to your morning shift and your afternoon shift, you have to give them a break. You cannot have them waive that meal period. But when it comes to your night auditor, you can have them waive that meal period. So your night auditor can technically sign a meal penalty waiver sheet that says that they will be taking an on-duty rest break and meal break, and then you are responsible for paying them their penalty for doing that. And keep in mind, a lot of people have only been paying a 1 hour penalty, but technically you do owe them a 2 hour penalty if you want to fully comply with the law. But it's unfortunately difficult for our smaller properties, but you do legally have to give your morning and afternoon shifts a break, a lunch break. And if you don't have a supervisor, then they also are supposed to be paid the penalty as well for missing that break. Any other questions? Well, I'll give it a couple more minutes for anybody else that wants to submit any questions, but otherwise, thank you all so much, and I look forward to hearing from you guys. Bye-bye.